So just a few housekeeping things before we get started this morning. So I am trying something a little bit new today. We're showing the actual presentation and not our lovely faces this morning. So go ahead and follow along on the presentation. I also posted a link to the presentation that's posted on our website so that y'all can use it as a reference later. I'm so sorry. I have a terrible cold, so I sound horrible this morning, but I assure you, I am here and ready to go. We sound worse than I am. So anyway, secondly, we are, so this event is going to be reposted on YouTube as well as hosted here on this website or on Facebook. So you guys can refer back to it later as we go. After the presentation's over, we're going to go ahead and answer some of our FAQs that we'll be posting on the website here later on this week. So go ahead and look out for that. And without further ado, I'm going to go ahead and turn it over to our Carrie Lewis. And she's going to be clicking through the presentation and getting started here. Guys, I'm so excited to see how many people from all over the state are here today. So that's awesome to see and hear from. So keep the comments going. We have one of our staff attorneys, actually not just a staff attorney, the Director of Enforcement here today. He's answering questions live in the chat boxes. So if you have questions and you want to post them and Carrie can't get to them right away, our very own Mark Moore will be here answering questions too. So let's get started. Carrie, go ahead.
Okay, good morning, everyone. I like that Christine said we sound bad, so already I'm thrown into that.
Sorry about that, Carrie. I had coffee, I promise. I'll get better.
Although I like this better than extreme close-up of the camera. So what I've done here is I've done a review. We already did one of these Facebook Live chats on the advertisement rules a couple months ago. I've been going around the state. Avis Wukesh, our chair, has been going around the state. Ms. Joel Mixon has been going around the state talking about the advertisement rule. So this really is a review, hopefully, for a lot of you. Although I'm hitting all the high points, I'm not going to go into the detail that we went into in our last review. But after we go through this slide presentation, I will take questions, and as Christine said, Mark Moore will answer questions as we go along. So let's go ahead and get started. See if I can make this work. Okay, so it's not working.
Oh, sorry, yes. Sorry, growing pains, guys. All right, there we go.
Here we go. Now let's start working. Okay, so as you should have heard by now, and I guess if you're on this Facebook Live, you have heard and you're trying to get in compliance, so good for you. We have two new rules that were adopted in November of last year that go into effect May 15th, so less than a month away. The first rule is 535-154. It deals with the registration and use of types of names, alternate names, team names, assumed business names, when they're used in advertisement. The second rule is the rule on actually the do's and don'ts of advertisements, what you can put, what you cannot put if you want to stay in compliance. So let's look at the names. Each alternate name, assumed business name, and team name must be registered with TREC before the name can be used in advertising. So any new name that y'all are establishing needs to be registered with us before May 15th if you're going to start using it in advertisement. So, or if you're using it before then, before May 15th. There are forms online for registration of all of those names. There is no fee associated with registering those names, so you can go to our website and print out a form, fill it out, and send it in. Very soon, we will have an online name management tool that will be available for the brokers to manage assumed business names and team names. So be looking for that, be looking for announcements for that. When it's ready, Christine will send that out. But we're trying to make it easier for the brokers to manage the names that they are registering, as well as for TREC staff to manage it. The broker registers the assumed business name and the team names. Okay, that's really no different than it's been in the past. It's just we've got a little different definitions for the names. And then the individual license holder registers any alternate name, and that makes sense because an alternate name is a variation of your own individual license name, a married name, a nickname, a maiden name, something like that. So let's look at the differences between types of names. The assumed business name, and here I put broker assumed business name, and that's for emphasis, okay? It is the broker's assumed business name, which is another name for a broker's business that can be used by all sponsored agents or brokers associated with the broker. Okay? Another name that indicates a broker's line of business, say property management has a different name or commercial has a different name, that's also a DBA, even though the use of that name may not be available to all sponsored sales agents and brokers associated with the broker. But it's not because they're forming teams, it's because they're not qualified, or the broker has determined they're not qualified to do property management or commercial business. So again, it's still a broker's assumed business name and not a team name. A team name, on the other hand, is a name used only by a team or group of one or more sponsored sales agents or brokers associated with the broker. Team names must end in team or group and cannot contain the words brokerage, company, or associates, or other similar terms. And those are terms that would imply that they're operating independently from the brokerage, which is what our rule says. An alternate name, as I just referred to, is a name used by an individual license holder other than the name on the individual's license, such as a middle name, married name, maiden name, or nickname. Be aware that common names for your license names, such as Kim for Kimberly or Bill for Williams, are not considered alternate names and do not have to be registered with TREC. That's just a common variation of your license name. What we want registered as an alternate name is something that's completely different, like Sparky Williams, or Betty Sue is a nickname for Kimberly, something like that, which you wouldn't be able to know by looking it up on our licensee search. So those types of names have to be registered. So let's look at the advertisement rule itself. What do you have to do? I keep saying this when I go out talking, but it really is two simple things. Must be included in each advertisement in a readily noticeable location. And by the way, readily noticeable does not mean using very light yellow ink on a white background. Okay, that's not readily noticeable. So, and readily noticeable doesn't mean that you put your team name and then the broker's name in a different color, lightly colored font, ink, where it's not really noticeable. So readily noticeable means just that, readily noticeable. Okay? The two things are the name of the license holder or team placing the advertisement. And by license holder, we mean sales agent or broker associate. And two, the broker's name in at least half the size of the largest contact information for any sales agent, associated broker, or team name contained in the advertisement. That's it. Those two things are the only things that TREC is requiring that be in your advertisements. We'll talk in a minute about things that are prohibited or could be considered a violation, but it's really a two-step process. Your name and your broker's name. And the size requirement is the same as our safe harbor has been for many, many years, so that has not changed. Okay, so what's prohibited? When would an advertisement be considered misleading or deceptive under the law? And there are about 20 of these if you look at the rule. I'm just going to go over 4 fairly new ones. The rest of them have been in our rules in the past, and are just reorganized and clarified, but they're really not new. And they are very logical if you go through and read them. So let's look at some of the ones that really are dealing with the differences in the names. So an advertisement that uses a title such as owner, president, CEO, COO, or something like that, founder was one that came up the other day in a question I had, uses a title in their email, on their website address, or on their advertisement that implies the sales agent is responsible for the operation of the brokerage is prohibited. You can't do that. An advertisement that contains a team name, where the team name contains terms that imply the team is offering brokerage services independent from its sponsoring broker, is not allowed. Those terms today include brokerage, company, and associates. Now you will see that the rule has the word realty in it. Realty is crossed out here because back in February, after receiving lots and lots of emails from different sources and input from stakeholder groups, the commission is on their May agenda going to propose removing realty from the restriction from team names. So just a brief history on that. Realty historically in the industry has meant brokerage. The reason that it's being removed, even though it has historically meant brokerage, from use with the team name, is because all team names have to end in team or group. So it's the name's not ending in realty. So it's not ending with what would be deemed to be brokerage, but it's ending in team or group. And it's been determined that the public is discerning enough to be able to tell the difference between realty when it's used inside of team and group and outside of team and group. So that is something that the commission has stated that they're going to do. It's going to be proposed at the May meeting, and they've instructed staff not to enforce against anyone using realty in a team or group name as this goes through the rulemaking process. Okay, let's look at another one that may be new to y'all. This is similar to what we've had in the past, but it's a clarification point. An advertisement is misleading if it contains the name of a sales agent whose name is in whole or in part used in a broker's name and implies the sales agent is responsible for the brokerage. So let's say my husband and I, he's a broker, I'm an agent, and we have a brokerage, or I should say he has a brokerage, and it's Lewis Realty. So we no longer are required today under the statute and the rules to put broker or sales agent. So if I just put Carrie Lewis, my name, who's placing the ad, and Lewis Realty, the broker's name, and half the size, at least half the size or more, it's going to be very hard for the public, another agent or a title company, to know my role in Lewis Realty. It could imply that I am in charge of the brokerage, that I am the broker. I am the Lewis of the brokerage, Lewis Realty, but I am not. I am the agent. The best way to handle this is to either simply put comma, sales agent, because then it's clear to everyone what my role is in terms of that Lewis Realty brokerage, or Lewis Realty can have another DBA that doesn't have the word Lewis in it that could be used in conjunction with the sales agent's name of Carrie Lewis. Okay, that should make sense when you think about it. Again, we're just trying to go for clarity. Remember, the statute says, the standards in the statute are that it cannot tend to mislead, lead, or be likely to deceive. Okay? All right, let's look at another one. This one I'm putting up because it ties into another rule. And when I've been out speaking at the listening tour and speaking to groups, I ask the question if people are aware of this particular one and the new rule that it relates to. 535.17 was updated. I asked for a show of hands how many people know that. And maybe a quarter of the room raised their hand. So this is important for y'all to know for two reasons. One, it is misleading to put something in an advertisement about the value of a property unless it is based on an appraisal that is disclosed and readily available upon request, or it's given in compliance with 535.17. So let's look at that so everybody knows what that means. 535.17 now includes estimated worth or sales price effective as of December 6, 2017. So there's a new written statement. So this applies not just to estimated worth or sales price statements, but it applies to all CMAs and BPOs as well, because that's what the rule relates to. So if you're not using this new statement that's here in red on your CMAs and BPOs, you need to be. Go back and look at Rule 535.17 and make sure that this new language is what you have in all of your CMAs, BPOs, estimated worth or value. So how does that work in an advertising context? So let's say I've got a website. Remember, website can be an advertisement, and usually is the way that we use the internet and websites today. And right on the front page of my website, it says, want to know the value of your home? I can sell it for you. Something like that. You guys are much more artful at that. That's why I'm not in advertising and sales. But let's say you say that and someone click here to find out the value of your home. So they click there and you use an AVM and it pops something up and you've got the value of the home right there. When that value pops up, right beneath it, you need to have this statement that's in red. Okay, the same statement that you use on a CMA or BPO. That this is an estimated sales price. It's not the same as an opinion of value. It's not the same as an appraisal developed by a licensed appraiser under the standards that they're required to use. And this is important information for consumers to know. I often tell people, and they sort of chuckle about it, but it really is the truth. If a real estate license holder tells a seller what they think the property is worth, and they get an offer, and they've got a contract, and the lender's appraiser comes in, and that appraiser comes back with a value that is substantially lower, or even $5,000, $10,000 lower, we sometimes get complaints over at our sister agency at the Texas Appraiser and Licensing and Certification Board. We get complaints on the appraiser saying the appraiser did their appraisal wrong because my real estate agent told me it was worth this. So that's how much weight what you tell them initially carries. So they need to understand what you're basing it on. Okay, so that really was my short and sweet review of the main points that you need to know for being in compliant with the rule. I don't know if Christine mentioned, I know she mentioned this in the blurb that she sent out to everybody about this session, but we have lots of information on our website. And if you just go in to our website and up in the search bar, just put in advertise without the E. Okay, so do we have any questions right now?
Yeah. She said, so Lindsay Martinez says, if I'm a sales agent, Jane Doe, and my broker has filed a corporate license with TREC called Jane Doe Real Estate, is that in compliance?
No, it is not. And that's a question that we've been getting. If you notice, the definition of team name talks about one or more sponsored license holders. So there is no provision under our rules for an individual sales agent to have their own assumed business name, at least for use in advertisement. So what would have to happen is Jane Doe Real Estate, you could use that, but you'd have to make it a team name, so it would have to end with team or group, even if you are an individual, or if you don't want to have team or group associated with your name, then you would just use Jane Doe, and you would not have real estate as part of your assumed business name. So that may have been compliant under our old rule. It is no longer compliant. And one of the reasons that the team name was distinguished from the assumed business name is because team names were given the equivalent status as an assumed business name, and a lot of times the broker's name never even showed up. And it was very confusing to consumers, to other license holders, and to title companies, just consumers in general. So the one thing that everyone agreed on who was working on this rule, including TAR, was that there needed to be a clear distinction between what's a broker's name, including a broker's assumed name, and a team name, which is a smaller subset of the brokerage.
So we had a couple of questions. I pulled up the the questions from the previous video stream, and a lot of questions about URL names, and that's been a question I've gotten a lot too. Maybe you want to delve into that a little bit more, but specifically, JJ asked, can an individual agent use their name and properties in advertising in the web address like johnjonesproperties.com?
Okay, so this is a tricky one. And it goes back to the overarching statutory requirement that your advertisement cannot be likely to deceive or tend to mislead. So TREC does not consider a URL or an email address in and of itself to be an advertisement. But when you're using a URL or an email address in an advertisement, and if the entire advertisement, it looks like the sales agent is in charge of a brokerage or is operating independently from the brokerage, then the whole ad will be misleading. So you kind of have to look at it as a whole. If it's just a way for someone to contact you, and the rest of the ad, it's very clear that you're working under a broker, and it's very clear the distinction between the broker and yourself, and that's just your URL or your email address, then you're probably okay. But if the main part of your ad is, call John Jones Properties, or contact johnjonesproperties.com, and the broker's name is there, but it's not really prominent. Again, if you comply with readily noticeable, you might be okay. So it really is a judgment call. When in doubt, use something else if you can. That's not going to be misleading. So properties sometimes sounds like a business, right?
Yeah. And we had a couple of people say, like, in a really clear, succinct way, the advertising rule is not applying to the URL. Like, technically, the URL names is not, the advertising rules don't apply.
Don't apply, but it is
Right.
contact information.
Right.
And if it's on your advertisement, we look at the whole advertisement, okay? So there's no magic formula. We look at the whole advertisement, and if a reasonable average person could be deceived or be misled that the sales agent is operating independent of a broker, then that's an issue.
Okay, so we're gonna, Tina says, if I use an email automation service for lead and nurturing, similar to Constant Contact, do I need to add the team logo to those emails as well? What if their emails are not set up for me to add a second logo?
So we don't control logos, and that's a really good question, because I'll answer your question, but let me just say first, even in the broker's name, you can't use a logo to substitute for the broker's name unless the logo has the broker's name completely written out. So you've got the logo, and then you've got the name of the brokerage, the registered license name or registered assumed business name of the broker is also there. And then what has to meet the size requirement there is the letters, the actual name, not the whole logo, but the actual name. So for a team name, if your advertisement has a second logo, that's fine. That's not a problem. But if you can't fit a second logo, the requirements that TREC has is just the team name and the broker's name in at least half the size. Yeah. So how you work that out with the lead generating service, that's kind of their business model, not ours.
Yeah. Okay, so license holder is Jane Elizabeth Doe. Is Liz Doe Group broker name allowable, or does that require the DBA form be submitted by the broker? That's this question
Okay,
here.
so you've got a lot packed into that question, so that's a good question. So first of all, Jane Elizabeth Doe, using Liz instead of, if you go by Liz Doe instead of Jane Elizabeth Doe, you would need to, first of all, register that as an alternate name because that is your middle name and not your first name. And somebody might not know what your first name is, what your middle name is. Even though Liz is a common derivative of Elizabeth, Elizabeth is not your first name. It's your middle name. So you probably want an alternate name registered for that. Now, when you're doing a group name, Liz Doe Group, that's a team name. And that is a team name registered by your broker. It's not an assumed business name registered by your broker. So maybe, we're still getting used to the new terminology, but yes, Liz Doe Group is a team name and it would be registered by your broker. Did I get everything that was in that question answered?
I think you did.
I kind of scrolled up on
So somebody else said, and here, that's the question that you were just answering, Derek.
Yeah. Mm-hmm.
So I think, yep, he says thank you. Awesome. Great. Okay, so the next question is from Yvonne. Can realtors still be used in lieu of real estate agent / sales agent?
Okay, so we don't regulate the use of the word realtor. If you're a member of the association, you have to use it in accordance with their copyright rules. Okay? So so you can use it at any time. In fact, you can use sales agent and broker at any time that you want to, whether it's going to make that, because you want to make your role clear. The example that I gave where I said that Carrie Lewis Realty, and the broker was my husband, I have to put sales agent. You cannot use realtor there because realtor could be a sales agent or a broker. And what I'm trying to do in that one case where the names are the same, I'm trying to make it very clear in my advertisement so that I don't mislead anybody of what my role is. And my role is sales agent.
Okay, so sorry, I'm just making sure we're getting all the questions answered. Okay, so I got this question from Nicole Torres Cook.
Okay.
This is an advertising question. When placing Facebook ads and an agent selects a targeted audience, does that violate any rules?
No, how you market, how you advertise, that's a business decision.
Yeah, and she specifically was referencing fair housing, but I don't know if we have any comments on fair housing rules.
Well, you cannot discriminate, right, in your real estate practice, and we do have a rule under 531 on that. But depending how you're targeting, I suppose you could run afoul, and then you'd get in trouble with the federal government on that. And if somebody complains, since we have a rule, we would investigate it and look at it as well. But people market to targeted groups all the time, so unless it was done in a way that blatantly, intentionally discriminated, you'd probably be okay.
Okay. So Perry says, my father and I have the same name. He is the broker, and his LLC is our last name, Realty LLC. My name appears with agent after it on our advertising. Are we in compliance because I'm stating I'm an agent and avoiding the chance of misleading the public and that they may think I'm the owner?
Okay, so this is actually a question that our executive director, Mr. O'Mixon, discussed in our very first session of these, and really you need to put sales agent and not agent, because agent could mean that could be the global agent, right? A broker is an agent for somebody. A sales agent actually works as an agent through the broker, and it connotes some type of agency. But sales agent is your licensed role. Yeah. That is different and distinct from broker. So in this case, I think you would need to put, to be absolutely certain, you would need to put sales agent.
Perry, I hope that answers your question, because I mean, it looks like you guys are trying to get in compliance. It looks like their answer in that one is just adding the word sales agent instead of agent afterwards, and then you'd be in compliance. So that's fairly easy. So Barbara Taylor says, so website, does it needs your name and broker on every page or just the first page? What has to be on your website? Is there a place to find info on just websites?
Okay, so no, we don't have just a guide for websites, if you will, but I go back to, what does the rule say? In a readily noticeable location. To me, that's the first page. That's the home page, right? Yeah. She's my social media web guru.
I thought I was a guru, and then I messed this whole video up. So sorry about that, guys. But promise.
I would not think that you would be required to put it on every page. But if it's on your home page, where they come, where they land, to me, that's a readily noticeable location. Yeah. So use common sense when you're thinking about these answers.
So it doesn't need to be on every, Barbara, to answer your questions. It doesn't need to be on every single page, as long as you're not like, the home page is in compliance, but then every other page on the website, the ones that you share, are completely misleading, and you're intentionally, trying to direct people to other places. We've seen all of it, and I would assume that somebody's going to try to be sneaky like that and do that. Right. To say, well, I'm in compliance according to this rule. Well, really, it comes down to this, Carrie, and I might be speaking here, but you just don't want to mislead people. So,
right.
If you're intending to mislead people, then you're probably in violation. I had one question emailed to me, and it said, how about using the word real estate professional instead of, I'm assuming that the person meant instead of CEO or, owner. Is there any distinction there? Is there any concern?
I don't have a concern with real estate professional because hopefully you are. We want all our license holders to be real estate professionals and take this as a profession. If you've ever heard Doug Olmixon speak, that's one of his main points, is this should be a profession that everyone involved should be proud of and should be striving to make this industry as professional as possible, because it helps not only industry, it helps all the consumers as well.
Okay, I'm getting an alternate name question here, which is interesting. Okay, looks like Mark Moore is still answering questions on the live video, by the way. So that's good, but just so that the crowd can see, can I use Tammy N.J as an alternate name, or does it have to be a full last name? The N and J are the initial of my middle and last name, which are registered with TREC as alternate names.
Yeah, that's a real close one. If it's registered as an alternate name, then somebody can find you in our license holder search. But I want to make this clarification. You cannot use a different last name unless you have legal documentation for it. And we've had this. We've had people submit a complete total alias that they just basically made up a name that they wanted to be known by in the real estate business. They didn't change their name legally. They didn't have a marriage or a divorce or anything where their last name changed. And you can't do that. You can't just make up a name and be somebody else in a business. You have to, The reason behind that is, like, let's say a consumer's trying to find somebody, like, they know their legal name, and this maybe a criminal or something comes up with a whole different name, right? And is advertising and stuff, and then you can't find anything about that person. And again, it comes back to, we don't want to mislead people. We want our consumers of Texas to be able to find you and find out the information they need to. So again, registering, be Carrie Lewis could
be misleading, right? I mean, it's a great name, but probably misleading to the people that are trying to find information about me. As we all know, Carrie has a huge criminal background, and I'm sure. Just kidding, everyone.
Don't Google me. Do not Google me.
So can we use branch as a satellite office? Can we use branch as a satellite office? Yeah, Diana, I'm thinking we're going to need a little bit more detail on that one. So if you can clarify your question, we'll get back to you. Let's see, is the domain name considered an alternate name? I think you covered this earlier.
Yeah, an alternate name is a name for an individual. Okay? So a domain name is not an alternate name.
Okay. Let's see. I've got lots of good questions here. And I'm going to try to is Jane Doe Realty in compliance, or should it be Jane Doe Realty Group?
Yeah, I think we already addressed that.
Yeah, that's good. You're good. So let's go ahead and, so as we've been prepping for this event, and over the last couple of months after the commission adopted these rules, we've gotten here at staff tons of really great questions. One of the things we're going to do after this event is add some, maybe some FAQs from this event, but we've already prepped some new FAQs that are going to be published on the website. When I share the whole video in one piece, we'll add these FAQs to our website and share it all in one package for everyone, hopefully to address a lot of your concerns. So what I'm going to have Carrie do is kind of pick out some of her favorite of them or hottest hot topic questions.
I'll talk about a couple, and it gets a little complicated. I get a lot of questions from associated brokers, and just because they're trying to understand, since they are a broker, they're not a sales agent, yet they're associated with a brokerage, how does that work in terms of advertising? So we've got a couple of questions that I think will address that. First one is, can an associated broker refer to himself or herself as a broker in an advertisement? And the answer is, if you're using the word broker alone, the answer is no. And again, we go back to misleading. You need to identify the role that you're undertaking in that brokerage. So as an associated broker, you'd have your name and the brokerage that you're associated with, their name, and at least half the size. If you want to let people know you're a broker, which is great, I mean, you worked hard to get that license, you can put comma associated broker, you can put broker associate, you can put associate broker. Any of those that indicate what your role is vis-a-vis the brokerage is fine. And keep in mind, when we're going through this, keep in mind that the broker or brokerage, I'll make that distinction just because it's easier when we're talking about associated broker, the contracts are signed by or taken in the name of the broker. So your listing agreement, your buyer's rep agreement, those are not taken in the name of a sales agent or an associated broker, although their names may be on there. It's an actual, a legal agreement with the brokerage. And that's who the consumer needs to understand is liable for complying with the terms of that legal agreement. And that's who administrative law, Trex laws, and civil courts hold ultimately responsible.
Okay. Okay, so Mitch says, we have submitted notice of a DBA assumed name in February. These are not updated under our brokerage number. Is there a way to follow up on these? Yes, send an email to our information at trek.texas.gov.
Yeah,
so one side note is, I'm sure you guys are aware, we're having a lot of processing delays. We're working on fixing that. At the end of this video, I'll address some of that for y'all. But we do publish on our website now the processing times of all of our document processing. So if you submit a DBA on a certain date, you can see which date we're working on from there. So I would recommend checking that out. That's on our homepage in the image slider on the top part of our website. It says processing dates updated. That's updated every Monday by 3 p.m. so that you can get that information and know where you are in the process. And hope that answered your question. My license is under my full name, first, middle, last. However, I go by my middle name. Therefore, all of my advertising uses my middle and last name. Is this not in compliance? And I'm assuming, Renee, you are an agent, and I'm hoping that kind of.
Yeah, so your license has your middle name in it. We've had this before. I'm going to look at our
enforcement director is over here.
We've required that if they're using their middle name that they file an alternate name certificate. So
yeah.
It's just, it's too hard for people to connect the dots.
Yeah. And Carrie, remind me, I might be wrong, but alternate name registration is not costly, is it?
No, any of the name registrations, they're all free.
Okay, so.
Alternate name, assumed business name, team name, all free.
So in the end, like, it might, if there's a concern, could you advise somebody, like, just go ahead and register?
Yeah,
There's no downside of doing so, and that way then you're totally covered.
Right.
You don't have to worry about it.
You don't have to worry about it, exactly.
Okay. Hopefully that answered your question. Okay, Renee, I hope that answered your question. Pepe says, are these rules for a home inspector also?
No.
No.
That was easy.
Easy, succinct. All right, do you want to go to your next one while we get...
Okay, let's find another one. This is one. Does TREC consider a sign on a building to be an advertisement? The answer is yes. If a sales agent's name or team name is on the building, then the broker's name needs to be there in at least half the size. Obviously, the brokerage name can be up there by itself, as it can be on an advertisement by itself. But the Lewis team, and I'm associated with Jane Doe Realty, I can't just have Lewis team because I'm holding myself out as a separate operation, and I'm not.
Yeah. So again, I got another couple of questions about using realtor or NAR logos or realtor logos. We already kind of covered that earlier in today's session, but just in case you missed it, just brief answer on that one because I've gotten like 3 or 4 questions about that.
Okay. So you can use on your advertisements whatever logos you want, whatever words you want, as long as it's not misleading. So first of all, as long as your name and the brokerage name is on there, at least half the size of the largest contact information, you've met the TREC requirements. If you want to add additional things to that advertisement, you are more than welcome to do that. Okay? So, and when and how you use the word realtor, you have to follow NAR's rules on that. Logos cannot substitute, in and of themselves, cannot substitute for the broker's name unless the logo itself has the broker's name as part of the logo, and where the broker's name is, that typeface is half the size of the largest contact information. So it's not the whole logo with the initials and the name. That is not what we're going to look at to be half the size. It's down here where the brokerage name is spelled out. That has to be half the size of the largest contact information.
Okay, and Frank, I'm sorry, I'm going to butcher your last name, but I hope you're not offended. Frank Stobert asked, can you reference cases that have caused lawyers to come up with this mess? In 15 years, I've never had a client ask me or be concerned about who my broker is. Well, I think in that, I might be overstepping here, but Frank, I think in that, your question is the answer. In 15 years, nobody's ever asked you who your broker is because consumers don't know that they should know who the broker is in order to contact them if there's a problem, which I think might be.
That's one way to look at it. And I will say, Frank, also, it was not lawyers who came up with this. This started as an initiative from several brokers, including the chair of our commission, went through many stakeholder groups, and a lot of the brokers who were involved with this, and again, including the Texas Association of Realtors, understood and thought there was a need to have a distinction between the broker's name and team name. Yeah. And, having the broker's name has always been a requirement in the rules. Right. What happened was the rules had assumed names conflated with team names. Yeah. And that created confusion. So the barn door got opened too wide, and now we're narrowing it back so that it's manageable.
Yeah. Ultimately, again, the rules and what the commission is trying to do here is make it so that a consumer could figure out who's in charge and make sure that, if they see a problem or run into a problem, that they know. Right. They can find and it's not misleading. Again, you might have the broker's name somewhere, but
right. And keep in mind also that the statute changed. Even though it took out requirement for broker and agent, the statute took one of the provisions that was in our existing rule and made it statutory, and that is a sales agent cannot have an advertisement that tends to imply that they're in charge of the brokerage operation.
Can you clarify what info needs to be on business cards for sales agents?
It's the same. A business card is an advertisement. So everything we've been talking about applies to business cards.
If a broker has a DBA of the MOS team and the brokerage is Diversified Realty Consultants, can I say, Carrie Askew, the MOS team, without the brokerage name?
No, you cannot.
No. Yep. That's actually exactly why the rule kind of was put into place, because it is confusing, right? I mean,
and if you go back to, I think it's like the third or fourth slide on the presentation, I say, what are the two things that you have to have? Actually, it's a little further in, but the first slide on 155, you have to have the name of the license holder or the team. So that's the sales agent, associated broker, or the team, and the broker's name in at least half the size of the largest contact information.
So as we get to the end of our hour here, I just want to do a quick review with Carrie here of kind of what are your main points that you want people to carry away from today's session, main points from the rules, like really brief, so that they have something to take away from.
So really there's really just two simple requirements and then several prohibitions that all have to do with not representing that you're in charge of the brokerage operation.
Right.
So if you understand the difference between a team name, which applies to a group or subset of license holders working under a brokerage, and a broker's assumed name, which applies to or is available to everybody in the brokerage, I think it becomes quite easy to follow the steps and be in compliance.
Okay. And yes, so Mitch had a question about alternate name. Is there a form? Yes, that form is actually already up on the website. Yes. And the team name form is up on the website as well. So
and the assumed business name form is up on the website.
Yeah, it's all up on the website. And a link to the advertising FAQs, today's presentation, the most recent article Carrie just published, our original article, the last town hall, lots of other helpful hints for this are all on our website. What I'm going to do is compile all of this into one page, share it all again. I'll post it in this event. I'll post it on our Facebook page. I'll make sure the website has it all listed so that y'all can all find the resources you need. And, maybe we need to do another FAQ session where Carrie is here to answer more questions so that people, today's unfortunate hiccup with dropping the video maybe made it so people couldn't ask the questions they needed to. So we'll look into doing maybe one more of these before May 15th.
But we are going to put the FAQs up online.
Yeah.
So I think that will help. And the article that was just published, if you didn't have a chance to read it, really goes through and distinguishes between the types of names and actually has some kind of check questions so you can check yourself when you're trying to decide what name you should be using.
Shannon, thanks so much. We're so glad you guys are enjoying these videos. We're enjoying doing it for you. I think it's really helpful for us as staff to kind of hear what you guys are asking to and engage with our license holders. So thank you guys so much for giving us the time, your time. So Ray just asked a quick question. What about Realty Life Team? I just joined.
Yeah, that's that's okay right now, and will be officially okay when we go through the rulemaking process starting May 7th.
Yeah. Okay. So, so Ray, I hope that answered your question. So, quick overview for our next events. Just in case there's any appraisers in the room, tomorrow we're doing an appraiser session. It's our first appraiser topic. We're going to be covering the new AQB requirements with our other general counsel for the appraiser board, Kristen Warman. So if you have time, go ahead and like us on Facebook on the Texas Appraiser Licensing and Certification Board. They're doing an event tomorrow at 10 a.m. Same kind of format, so you can ask your questions there. And if you want us to, and you want to post your questions here, we'll try to get back to them on this comment stream here, or you can send us your questions via Facebook, and we'll try to get back to you as soon as possible about those. Just in case you missed it, kind of overview, our executive director just posted a message on our website about our communications issues that we've been having in our customer service issues. I wanted to make sure that you guys were aware that that was published. I know we've gotten a couple of comments about why is it taking you so long to process stuff. I think that letter would answer some of your questions and show you kind of the direction the agency is headed. So I urge you to check that out. That's also in our image letter on our homepage. And we're planning a couple of more of these events, and we'll keep them coming. So if you have any suggestions for topics you'd like us to cover, again, go ahead and post them here, and we'll get started. So thanks so much again, Carrie, for spending the time with us this morning, and we hope you guys enjoyed it, and we'll talk to you guys soon. Thanks so much. Bye, guys.
Bye-bye.